a couple things preliminarily and then respond to some points. The first thing is changing the law, adopting SB444 does not mean that a defendant does not have all of their constitutional rights and the ability to defend themselves against a defamation claim that has shown initial merit. It does not change that. With apologies to Assemblyman Jones, I realize that I answered more of your question, but I want to answer your question now fully. I promise you it was not on purpose. But people have said there's no example of a case that's been filed that has somehow been harmed by the existing law. And that is because, as a practical matter, when somebody who is considering a case like me, in most circumstances, particularly a case that requires proof of knowledge of falsity, you cannot file it here under this statute. And that is not theoretical, that is real. There is more than one case that I have filed for Nevada residents, businesses that have not been mentioned here in other states because it could not proceed. In other states where courts have found that the claim was meritorious enough to proceed past initial motions. So it's a practical effect. And I told you about, for example, the doctor on Yelp who has been falsely accused of committing malpractice. That's a real case that I told the person they could not file here because he would be putting his finances at risk if he could not make the showing by clear and convincing evidence that the person knew it was false, though it was absolutely false. So, in matters of public interest and why one might get more initial protection than the other is a very good analysis for this. Again, these people, it doesn't matter. Matter of public interest, they're still going to have all of their constitutional rights and be able to defend the lawsuit. Everybody who is a defendant in any lawsuit has to face the possibility that they're going to spend a lot of money to defend themselves. What is going to be subject to this special motion? Now, I want to clarify because maybe it'll affect the ears with which the listening occurs, how this SB 444 came to be, who's behind it. So as soon as I missed it the last time around, as soon as the statute that exists came out, 2 years ago, I recognized what I think are very serious issues that impinge on First Amendment right to petition. And I started working very hard. I started talking to lots of people about, because I'm not familiar with the process, about how to do this. And I am thankful that a client that I work for in the litigation context, but that I do not work for today, and I'm not being paid by today, that when it was explained to them the impact that this can have on business negatively, agreed and was willing to put their know-how behind it and assist me, really, in being able to get this before you today. That's how we got here. And because it's been raised, I want to make something else abundantly clear, because I'm very familiar with the case that I believe it was Mr. Mitchell talked about, the Wynn case Mr. Smith talked about, thank you. The Wynn case in California against Mr. Chanos that was recently dismissed on an anti-SLAPP motion in California. It shall not surprise you that I disagree with the court's decision in that case, and it shall not surprise you that we are appealing. But I will tell you that if the same judge, making what I think was the same mistake, but if the same judge was considering the same case under SB 444, the case would have been dismissed. Because what SB 444 does is ensure that meritless lawsuits are dismissed. And I hear case. And as you know, most cases don't ever get to the end.